Today we're going to talk about preparing for mediation. The most important thing to have a successful mediation and a productive mediation is for both the lawyers involved and the parties involved to be prepared. We're going to talk first about how the lawyers need to prepare for a mediation. The first thing the lawyers need to do is to become aware and informed about the facts of the dispute. You can become aware and informed about the facts of the dispute either by talking directly to the client or getting that information secondhand from a paralegal or an associate or an adjuster in the case of an insurance company. Either way, the first thing and the most important thing is to become aware of the facts. Next, become familiar with the law. Again, the lawyers can do their own legal research, or they can read memos prepared by their paralegal or their associate. But they need to know the legal issues involved and what the state of the law is on resolving those legal issues. Then they should become familiar with the accrued expenses in the case, because every client is going to want to know what they're in the case for in terms of costs. And in the case of the plaintiff, they're going to want to know what they net from the case after your fee and after the payment of expenses. Next, you're going to want to set aside enough time for the mediation. You don't want to have a mediation that's progressing and productive and have to end it prematurely because a lawyer's got to catch a plane or he's got to go to another meeting. So make sure you set aside enough time for the mediation. That goes for the client too. Make sure that your client has set aside enough time for the mediation. You're also going to want to know how similar cases have turned out in your jurisdiction. So you're going to want to do research on the jury verdicts and settlements in your area that involve your type of dispute. Just as lawyers need to prepare for a mediation before going to the mediation, clients and parties to litigation also need to be prepared. The first thing they need to do is to make sure that they've set aside enough time for the mediation. You don't want to be making progress towards settlement in a mediation and have the client say that they need to go pick the kids up from school or they have to go to another meeting. Next, make sure that you as the lawyer discuss with your client what their expectations are for the mediation. Talk to them about mediation and what mediation is like, what they can expect, and find out what your client expects from the mediation. Make sure you answer any questions the client may have about mediation, and make sure you discuss with the client what their settlement position is going to be during the mediation. Next, the client has to be prepared to make a decision. If you're making progress toward a settlement and a favorable settlement proposal is made by the other side, the client has to be ready to pull the trigger and agree to that proposal or to make a counter proposal. So make sure that the clients are prepared to make a decision. If they need to discuss the decision with somebody else outside the mediation in a phone call or text message, make sure to have that other third party available so that your client can get in touch with them and get the authority or the input that they need to make a decision. Make sure that your client gets a good night rest before the mediation, and make sure that they eat a good meal before the mediation, because mediations can be stressful for the client and sometimes they can go longer than the client expects them to go. So make sure that they're well rested and that they're not hungry.